and you're very welcome to episode 61 of The Fifth Court, a podcast on legal affairs presented by myself, Peter Leonard, barrister.
Myself, Mark Tottenham, barrister and editor of Decisive Law Reports.
Mark, good to see you as always. And last week, you will recall, we had a really fascinating discussion with Ian Drennan, the Chief Executive of the Corporate Enforcement Authority. And we talked about the authority's role in policing the companies out there. What did you think of that?
I think white-collar criminals need to look very carefully at what they're doing.
Oh, no, it was really good. Fascinating stuff altogether. Well, today we also have an interview with another big player in the administration of this dear state of ours, as we welcome to the studio Helen Dixon, who later this year will step down after 10 years as Ireland's Data Protection Commissioner. And in fairness, I suppose, Ireland being the centre of the world when it comes to social media and all those huge companies, she's kind of the Data Protection Commissioner for Europe, really, isn't she?
Europe, Middle East and Africa very often, yeah.
Yeah. So she's leaving her job. So we want to talk about where stands data protection as we speak, and we can talk about her future and all that sort of stuff. Really looking forward to this interview. Okay, but first we're going to look at 3 cases you have identified from the Decisive website. In our first case this week, we look at the effect of an expression of doubt. Mark, you're going to have to explain that. In a tax return, an expression of doubt in a tax return when dealing with a complex piece of tax avoidance. This is the case of Thornton versus the Revenue Commissioners, and it's a decision of Mr. Justice Senan Allen. And the use of expressions of doubt in tax returns was not deemed sufficient to avoid the imposition of penalties, I believe.
Yeah, well, I know you love a tax case, Peter, and this is one that involved a very complex, I'm not even going to start trying to explain it, but it involved dividend purchase transactions arising from a syndicate dealing with the British Virgin Islands. And so what happened was, basically, when you're engaging in a novel piece of tax avoidance, the revenue often have to rule on whether or not you can avoid the tax in question. And what you're sometimes able to do is to put in an expression of doubt, which is where you say, I'm not quite sure if this is legitimate or not. And that, so you're highlighting to the revenue, and then if they take a benign view of it, then you won't have to pay the penalties, you just have to pay the tax. But what they said here was they used an expression of doubt in what was quite clearly a questionable tax avoidance mechanism. And the fact that they'd stuck the expression of doubt into certain tax returns was not going to be enough to avoid penalties. It sounds almost Augustinian, doesn't it? Lord, make me pure, but not yet. You know? Well, or I'm not quite sure if I'm good.
Okay, very good, Mark. Okay, second case today. There was a claim against architects for negligence in the design and build of a house, which was found to have structural defects. The claim was issued in 2012. And there was a long period of inactivity. I feel a delay case coming on, Mark.
It's another delay case, and it's a decision of Mr. Justice Noonan. It's a straightforward negligence case involving
architects. We should
architects.
say it's called Beggan and Deegan.
Yeah.
Okay.
And what Mr. Justice Noonan said was there are an awful lot of these delay cases, and you will agree with that, I think, Peter. There's a lot of delay cases, and with the result that there's an awful lot of case law on delay. And just this quotation just gives a flavour of it. He says, this appeal provides a good example, with each side arguing persuasively that different cases support the outcome they seek. With so many judgments to choose from, one has to be cautious in placing reliance on isolated statements that may appear to support one side or the other. So he's saying there's too much case law on delay, and I think really the rules on delay are pretty clear at this stage. You look at the delay itself, you look at the prejudice, and you look at the balance of justice. And as he said himself, ultimately the issue is whether you can get a fair trial.
Okay, fair enough. And finally this evening, a child claimed damages for personal injury arising from a fall from monkey bars in a playground. The judge had some comments to make about expert evidence in the case. She also said that such bars carried an inevitable risk of accidents. So Mark, can you tell us all about this one?
Yeah, so as you said, it's a case where a child fell from monkey bars, and there are monkey bars in a lot of playgrounds. This child fell. And so the issue was there an issue with the monkey bars themselves? Had they been properly installed? Had they been properly maintained? And the plaintiff in the case retained an expert witness who had looked at an American website that he said gave an authority that there were problems with this kind of monkey bar. He said he'd researched safety standards for this type of arched monkey bar and located the National Safety Council, a US non-profit body, which apparently stated in a report that the number of injuries caused by monkey bars is so significant that many experts recommend their removal from all playgrounds. However, he didn't actually produce this report, and the comment from Ms. Justice Bolger should be borne in mind by any expert witness. She said, "I found the basis for the engineer's contrary view lacked substance, particularly in his reliance on an unclear criticism made by a US organization with unspecified credentials by reference to unidentified experts on an unidentified basis." So if you're going to refer to a report, you need to open it and establish its credentials.
And what about the child? Did the child get compensation?
Was unsuccessful in the case because he took the view that the monkey bars had been properly maintained and
they're
installed.
Just inherently dangerous.
No, she said that, well, there's an inevitable risk of an accident, but if you want to have monkey bars, if you want to have playground equipment, then provided they're properly installed and maintained, then there's no negligence on the part of the owner.
Oh, okay, very interesting. All right, back shortly with Helen Dixon.
Silence in the Fifth Court.
So we are delighted to be joined in the studio today by Helen Dixon, who is the Data Protection Commissioner. Now, as all listeners will know, our Data Protection Office was based in Portarlington, a very small office until a few years ago, and is now one of the biggest regulators of data protection probably in the world. So, Helen, thank you very much for joining us in the studio. Maybe you could give us a bit of personal history. Did you always want to be a Data Protection Commissioner?
Not exactly. I was born and raised in Athlone. I went to school in Our Lady's Bower in Athlone. I did the Leaving Cert very young. I had very little experience of the world. Didn't really know what I wanted to study, so I ended up doing a primary degree in French and German. No real inklings of Data Protection Commission at that point. And then I went on and I did a master's at UCD in European Economic and Public Affairs under the late Richard Sinnott. And after that, I looked to enter the workplace. And actually, primarily because of my languages, my French and German, I was hired by a technology multinational that had its Europe, Middle East and Africa base here in Ireland. And then I went on and worked for a second.
Are you able to say which tech multinational that was?
The first one I worked for was a small family-owned, very profitable little company called Worth Data, probably not well known. It was a barcode reader manufacturer. But I learned loads there in a family-owned company. It's small enough that you get to do everything and you get an insight.
Did you say it was a multinational though? I mean,
it was a multinational.
So it wasn't an Irish-based.
It was not. It was a California-based company that actually at the time had decided it wanted to move into Europe, partly as a type of failover because of all of the power cuts that the business was suffering in California. They had a very intermittent electricity supply, and they wanted a base in Europe so that they had some failover. So actually, they were interesting, the couple that owned the company, because they travelled over to Europe, literally self-planned, went around, fell in love with Switzerland, the mountains, the scenery, and established their European base there. And it was only when it was operational that they noticed it was outside the EU and that customs and duties were having to be paid. And it was extremely difficult to recruit staff, as it turned out in Switzerland as well. So I came on board when they were transitioning the operation from Switzerland to Ireland.
And was the attraction of Ireland the attraction that we always hear these days, you know, the English language, the common law and the low corporate tax rate?
It was, and it was very much the ease of doing business here. They had that experience where they'd established in Switzerland and it just turned out to be the wrong business model for shipping into the UK, France and Germany at the time. And they were attracted to Ireland because it was easy to do business here. They made contacts that showed them how to get set up, that introduced them to potential staff like me that they were able to hire quickly and bring on board, and who were able to speak languages and serve the market from Ireland. So it was all of those things. I think tax.
You would have had an insight into the mentality of a US company setting up here then. I mean,
very much so.
You've seen it from the ground up.
Absolutely, and would have been involved as they were procuring legal advisors and different types of advisors here in terms of setting up, you know, their accounting and bookkeeping element of the business here. So very much key insights into the positive view of Ireland.
Yeah. And Helen, can I just ask you, and it's lovely to meet you, and you turned your back then on that wonderful commercial world, that the international commerce and all that sort of stuff, and you decided to become a public servant. So will you tell us about that transition?
I will. So after that small company, I went on and worked for a big publicly listed company, Citrix, based out in East Point Business Park. And again, a huge learning experience. Great fun working there as well. A very vibrant social and sports scene outside of the hard work by day. So I was very happy there. But I got that niggling feeling in my early 30s that there might be more deeper satisfaction to be attained in a different type of work. And I've read subsequently this comes across a lot of people in their early 30s.
So the state was calling. Is it a bit like St. Patrick getting kind of visitations to come back and save Ireland? Do you want to kind of save the state?
It wasn't necessarily the state. I actually sat all 8 of the FE1 Law Society exams and thought maybe the deeper meaning would be derived from becoming a solicitor. I thought about teaching. I think I'd be a terrible teacher, but I thought about it. So it wasn't necessarily just the state, but policy attracted me. And at the time, as I was sitting the FE1 exams and contemplating whether I would apply for an apprenticeship and go to Blackhall Place, the civil service opened up the first ever senior management competition. So in fact, I came in as the first ever external assistant principal officer into the civil service. And the Department of Enterprise took me in, and I had a fascinating policy role as my first assignment, overseeing Ireland's fledgling investment in basic research through what was our new Science Foundation at the time, Science Foundation Ireland. So again, an enormous learning experience and insight into serving the political system, but also how the system serves the public.
Wow, so what a wonderful opportunity, I mean, to do that. And in terms of the world of data protection, how did you move into that space?
So I had a number of roles in the public sector after the Science Foundation Ireland role. I oversaw the work permits, green cards and economic migration policy area of the Department of Enterprise. And I was then assigned in 2009 to the company's registration office as registrar. And of course, there I was dealing with a vast register of data, and data was the name of the game. And indeed, making public that data was the name of the game on the register.
And if I could just remind listeners, last week's episode was with Ian Drennan, who is now the head of the Corporate Enforcement Agency. I think you would have been working with him at that stage with the Registrar of Companies.
So we would have been adjacent offices. So while we regulated the filing requirements of companies under company law, he, of course, regulated other aspects in terms of directors. So we had not overlapping roles, but complementary roles in terms of the Companies Act. So while I was Registrar of Companies, there was a lot of work in train for the ultimate adoption of the new Companies Act in 2014, which is, of course, a massive change in corporate law in Ireland, the biggest change in 50 years at the time. And I was a member throughout that time of the Company Law Review Group. It was chaired at the time by Dr. Tom Courtney. And I was part of a subgroup that was looking again at the question of whether a director's home address and date of birth should appropriately be published on the public register, or whether they should be kept private. And this was a big question that had arisen multiple times. And I was fascinated as part of that subgroup with all the brilliant lawyers that were part of it and business people at looking at the nuance of how you came to a decision on where the balance properly lay and how reasonable people could come to reasonable different conclusions on the same question. And that's really where I developed an interest in it. I was interested in the nuance of it, and I was interested in that whole question of the right to data protection, but the circumstances in which it has to cede to an interference that should and will happen. And that's really what...
So did you ever work in that wonderful premises you guys used to have over the Londis in Portarlington? Was that the case? Who was your colleague, Billy, or your predecessor, Billy?
Billy Hawkes.
Billy Hawkes, yes. And wasn't the office, this is a very trite point, but I find it interesting, but like Data Protection Commissioner was based over kind of a convenience store, let's just say, in Portarlington. Am I right about that?
That's right. It was originally based in Dublin, and then during Billy Hawke's time, I think around 2005, it was part of the government's decentralisation programme, and it decentralised from, I think it was the Irish Life Mall, it was on Abbey Street, down to Portarlington. And Billy often used to argue, and I don't think he was wrong, that you can regulate from anywhere.
Yes, absolutely.
But of course...
And no aspersions on Portarlington. I'm sorry if that's the way it came across.
No, but
it was always a curiosity.
It became a perception issue that it was alleged that Ireland wasn't taking data protection seriously because as the big internet platforms began to move into Ireland, photographs of the office over the supermarket rather famously began to circulate and it was wielded against Ireland. But no, I was never based there because actually when I was hired on foot of an open international competition in 2014, I was brought in with a mandate to re-establish a Dublin headquarters for the office. There was no question, of course, of eliminating Portarlington. All of our corporate memory was now there, an excellent staff, but it was to re-establish a base in Dublin and to start building out and resourcing the Data Protection Authority for what was to become the GDPR.
And so how big is the agency now? How many staff?
So we have over 230 staff today.
Right.
We have still 30 based in Portarlington and then about 200 in Dublin.
And because Ireland is now really the headquarters of so many huge international tech firms for the Europe, Middle East and Africa, I mean, Twitter, Facebook, Google, LinkedIn, I mean, so many of them are based here. So many of them are holding a vast quantity of private information, photographs and all that sort of thing. I mean, it's not unreasonable to say that you are in charge of one of the most important data protection agencies in the world. Is that a fair comment?
I think it is a fair comment. Ireland has a lot of responsibility and the Data Protection Commission has a lot of responsibility. And as both of you probably know, the GDPR, when it came into application in 2018, for the first time introduced something called a one-stop shop for multinationals under EU data protection law, which meant that they were regulated primarily by the regulator in the country in which they had what's called their main establishment.
But given that the European Union with whatever, 300-400 million citizens, probably more, a vast quantity of those adults have information that is stored in Ireland by these huge companies. And so if they have a data protection complaint, it would be addressed to your office.
That's right. I mean, just to be pedantic, it's not about where the data is stored. It's not necessarily that the data is stored in Ireland. It's about where the control around decision making for the data of EU users is. And that is here in Ireland. So you're absolutely right. If an individual in Germany has a complaint in relation to how their personal data is being processed by Facebook, it is transferred to the Irish Data Protection Commission, or they can lodge it directly with us.
And can I just come in there, Helen, and just go back a little bit? So you succeeded Billy Hawkes as the Data Protection Commissioner. And on your watch, and you made reference there to the GDPR regulations that came in from Europe, and then we had the GDPR Act 2018 that was introduced in Irish legislation. Will you tell us how much of a game changer that was?
Oh, it was a completely transformative game changer. I know lots of people debate this and they say, well, look, we always had the EU Data Protection Directive. The principles are still the same. It was really just a small evolution to the GDPR. It wasn't in actual fact, and particularly by reference to the one-stop shop. So the principles are still the same in terms of fair processing and transparency and security and integrity of the data and so on. But the one-stop shop created specific procedural obligations and substantive obligations for the Irish DPC. So in the run-up, the GDPR was adopted in 2016. So there was a very tight 2-year turnaround for the 2018 Act to be adopted, but also for the Irish Data Protection Commission to prepare. So we were recruiting staff at a great pace. We were trying to understand the provisions in the GDPR and how the 2018 Act might eventually look as it was passing through the Oireachtas. and we were trying to adapt our procedures internally. So basic things happened, like the notification requirement of processing activities that existed under the directive was eliminated. So we had to get rid of some processes and phase out some processes. But then the whole, I will call it, convoluted means by which cross-border cases are handled under the GDPR necessitated a huge amount of procedural preparation. And the other significant thing that, of course, is such an obvious point, I almost didn't mention it. The GDPR brought in a very hard-edged enforcement regime. There were no fining provisions available under the directive or through the national acts that transpose the directive. The GDPR brought in those massive fines of up to 4% of turnover of global undertakings.
Have now fined companies for several $100 million at this stage.
Count higher. It's several billion in fines have been implemented by the Irish DPC.
How does that feel like?
Well, I've never actually touched any of it. It goes to the central exchequer. And of course, we haven't collected all of it. We've collected about 20 million so far. Again, all gone directly to the central exchequer. Once an appeal is lodged against a decision made, it has the effect of staying the order to pay the fine.
And the appeal is to the Irish High Court?
The appeal is to the Irish High Court, but in many of the cases that we've dealt with, there's also been a parallel action taken against the European Data Protection Board element of our final decisions. The one-stop shop is complex. I'm happy to lay it all out in all the detail, but you may not want it.
As Mark said, because Ireland is the centre of the world, as we all know, and seems to be very important for all these massive international social media and data companies. So does that mean on speed dial you have like Elon Musk, you can ring him, Mark Zuckerberg, is like, I'm being slightly cheesy here, but Ireland has a very big role to play in policing how those major international companies go about processing their data and their obligations. Isn't that the case?
That is the case. And so it involves engaging with those organizations at lots of different levels. So, of course, we're handling complaints in respect to their processing every day, and we're in contact with them in terms of asking for their responses to complaints and seeking resolution of complaints. We're also investigating them in terms of large-scale investigations that we have underway. And so they're quite formal and on the record, and high volumes of correspondence exchanged. We also have more informal exchanges with them where we're looking for them to share with us what new services are coming on stream, what the implications may be, so that we can get some advanced insight into them. And then, of course, at times, there is a role for me to engage with the most senior people. I'm not going to start name dropping, but I have, of course, met with the CEOs, the general counsel of many, if not most, of these organizations at various times, depending on what buttons we need to press for what reason. Okay. So, yes.
Now, about 12 or 18 months ago, I think a group of MEPs came to Ireland, and they were very exercised about the work of the Irish Data Protection Commission. They made quite a song and dance about saying that it wasn't adequately resourced, it wasn't doing its job properly, that kind of thing. What were the specific concerns, and did you feel that you were in a position to allay them?
Oh, very much in a position to allay them. So you're right, a group of parliamentarians from the Civil Liberties Committee of the European Parliament came to Dublin, and they wanted to look at what were criticisms that were being expressed about the Irish data protection regime. So they had a whole couple of days of an agenda where they met civil society bodies, they met the Joint Justice Oireachtas Committee, they met various politicians, the Department of Justice, and their last port of call was me and the Irish Data Protection Commission. And they were very exercised, as you said, by the time they arrived at the Irish Data Protection Commission, but by the time they left, after several hours of a meeting, they were significantly reassured. They were significantly better informed. We got onto a much more positive footing. A huge problem in EU data protection terms is that, first of all, that one-stop shop, which we could talk about for hours, is very, very procedurally complex and it's not well understood. The second thing is that while Europe aims for harmonization through the GDPR in terms of data protection law, at the centre, the European Data Protection Board doesn't have any centralized statistics. There are no reliable databases. And into that vacuum comes a lot of misinformation and misrepresentation in terms of how we do our work. So once I get the opportunity to explain generally.
Sounds like you won them over big time there, Helen. But can I the curious committee that you referred to there, Mark referred to these MEPs, but you said they were from the Civil Liberties Committee. Let's talk about that. I mean, GDPR, and I sound like this is a song I've sung before on this show, but is GDPR a little bit too much? I mean, are we over-regulated now? I mean, you're in a sports club, somebody takes a photograph, can you put it up, can you display it? This sort of stuff. It's all got a bit crazy, hasn't it?
I don't think we're over-regulated. GDPR and those principles are really common sense. But what, of course, you do see is a type of implementation that's really so risk-averse and defensive in its approach to data that it's really not protective of individuals, but is annoying them. And we've heard that criticism in terms of community groups where they feel they can't put up a rota anymore of who's going to do the coffee after games, or residents groups where they're now afraid to share numbers between neighbours and so on.
Well, can they? Sorry, Mark, and I'll let you in here, but can they? Can we get that now? So tell the great unwashed out there what they can do and what they can't do.
Look, the GDPR isn't intending to stop people living their lives. And it is about risk. And the GDPR promotes a risk-based approach. So the measures organizations need to take are supposed to be proportionate to the risk. But none of us are good at measuring risk. And so you can get, as I said, defensive reactions, and then you can get approaches where the risk hasn't been appropriately measured at all. So,
And is it a little bit like health and safety that a lot of organizations just use GDPR as an excuse not to do something, not to provide information, not to be cooperative? They sort of say, "Oh, we can't do that because GDPR." Do you think there's sort of an excessive citing of GDPR where it's not really relevant?
Oh, that for sure. I mean, I'm not sure that we do often hear the complaint that organizations are deliberately using it as an excuse. I'm not so sure it's that. I think it's more the latter in terms of what you said. It's overly cited, and people bring it into things where it really isn't relevant, because this is one of the side effects of having a very hard enforcement edge to the law. People are nervous that they're going to be sanctioned.
You're coming up towards the end of 10 years in the role. How do you reflect on your achievements?
Oh, well, I think the key one is what we've discussed here today. It was a very small, regionally based office in Ireland when I arrived in 2014. It's now an internationally recognised, well-regarded, credible data protection authority that's leading on enforcement globally, and that has handled many of the cutting-edge cases in terms of internet companies and social media platforms. So
you
there's a lot more
you're
to
handing
do.
it over to your successor in good shape and taking it to the next stage of regulating AI and all of the challenges that are going to come with that.
There's plenty to be done, but there is a fantastic team at the Data Protection Commission, and certainly whoever inherits that team is inheriting a wealth of expertise and commitment.
Helen, we're going to have to ask you about the next chapter. But before I do that, can I just go back a little bit? And just, we hear, the big international companies, they're the ones that get the headlines. They're the ones that get the media coverage. But you are there for everybody, aren't you? And, let's talk about the ordinary punter who believes that their data has been breached. They've engaged with a company. They gave their details confidentially, and then suddenly they find they have been phoned by another operation that might have got that data. They can make a complaint to you, or your successor, as it's going to be in a little while. But they can do that, can't they?
Oh, they can. So we handle thousands of complaints every year. And each year when we launch our annual report around February, we produce a lot of case studies to illustrate to people how they can empower themselves to give effect to their rights. The most frequent type of complaint we get is about access rights. So each individual has a right to access a copy of their personal data. And we're finding frequently that in terms of the complaints we get, organizations are ignoring individuals completely. It can be that whoever receives the access request doesn't recognize it as a request under law to access data, or they're simply being ignored by some of the smaller organizations, or where the request is responded to, the organization has redacted and restricted the right so much that it's not effective. So we intervene on all of those cases.
What about data breaches? And we have covered on this show previously, we had an interview with two people who talked about the recent developments in the European Court of Justice in the Austrian Post case, where they talked about non-material damage.
Mm-hmm.
So just to explain to people out there, obviously material damage is maybe a business suffering as a result of a data breach, etc. But non-material damage is, let's say, somebody being upset, an individual, for example, being upset about the fact that their data protection rights were breached. And now there is a mechanism in the Irish courts where somebody can get redress for that. They can get compensation. Isn't that the case?
That is the case. That was another introduction under the GDPR where individuals have a private right of action and they can go to court and they can seek compensation if they have suffered damage as a result of an infringement of the GDPR. So in fact, interestingly, just last year in 2023, the first damages case under the 2018 Act went to hearing in Ireland. There have been a couple of cases, but they've all settled outside of court. The first one that went to hearing was heard by Judge O'Connor, John O'Connor, in the Circuit Court. And it was a case called Kaminsky versus Ballymaguire Foods. And in that case, Judge O'Connor followed the CJU rulings, where he found that mere upset wouldn't be enough to ground damages and that there had to be a link between the infringement and the damages. But in that case, he awarded €2,000 to Mr. Kaminsky on the basis that Mr. Kaminsky's employer had infringed his GDPR
And the damages
rights.
were pegged at a very low level, kind of personal injuries type, psychiatric injury type level of damages, I think. Isn't that really the way it's been
and that
pitched?
was a case where Mr. Kaminsky had suffered embarrassment and
Yes.
distress as a result of actions their employer took.
It was an agricultural
displaying a
training video or something,
That's
wasn't it? Yes.
Exactly where he was being used.
But it's very important to say that. So for people out there now, if they're upset by something, they don't have to show that their business was affected or that they had experienced a loss as a result of it.
Yeah,
They
it
can be
doesn't have to be
emotionally
financial
affected by
loss.
that, and they still have rights now, which I think is very important.
Okay, so can I ask you then about your plans for the future? When you're stepping down in a month's time, is it?
Yes, that's right. I finish up in February. In fact, I'm going to continue on the regulatory streak. I'm going to become a commissioner for telecommunications regulation in February.
When you say a commissioner, do you mean the commissioner for telecommunications?
No, I'm going to become a commissioner because Comreg, as the regulatory body is called, has two existing commissioners.
Okay.
And I will join those two as a 3-person commission from February. So lots to learn.
Fantastic. And we have a final question that we always ask our guests, which I think we've notified you of. Do you have a book or a film that you would like to recommend to our listeners?
I'll mention one of each that I've come across recently. In terms of the book, I would recommend Kidnapped, the...
Robert Louis Stevenson?
No, the...
We featured the Kidnapping. Sorry, that was the one we featured on this show. Sorry, you're talking about something else.
Conlon and McGreevy are the journalists that wrote it. It's about Don Tidey, Kidnapping.
We've done an episode on that.
And the Manhunt.
loved it.
Oh, right.
Yes.
Okay, really interesting reflection. And lots of little detail in it that I enjoyed. And then in terms of film, definitely the film that has had the most impact on me recently was that short documentary on RTE, Patrick, A Young Traveller Lost.
Okay.
Incredibly sad, extremely impactful in terms of reflecting on that awful habit we always have of making insiders and outsiders out of everything. Sure. And really, it's one I would commend to everyone to watch.
And probably still available on Player.
I saw it on the RTE Player, yeah.
Fantastic. Okay, well, thank you very much, Helen Dixon, for joining us here in the Fifth Court.
You're very welcome.
The Fifth Court will adjourn until next week.
And that's all from this edition of The Fifth Court. We hope you have enjoyed it. Can we say a huge thank you to our guest, Helen Dixon, Ireland's Data Protection Commissioner, for a little while longer, Mark, but she's moving off to pastures new.
Indeed, yeah. But I think she's, from her account, she's done an amazing job of building up a very small organisation to an international leader.
Yeah. And we wish her very well with her new role with Comreg. Well, anyway, before we go, can I say a huge thank you to our producer, Conal O'Moroyne, and to Lee Brennan of the Dublin South Podcast Studios for their wonderful work in recording this show. So from me, Peter Leonard.
Myself, Mark Tottenham.
Thank you for listening, and we'll see you soon in The Fifth Court.